Bargaining power is real. We can all abstractly issue spot and say, I spotted, like in law school, this issue here, that this is a big problem. But if the deal is a must-do for your client, then giving good advice is a much bigger picture problem.
Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, media, tech, and entertainment lawyer Darlene Tonelli breaks down the Salesforce Master Services Agreement. As former in-house counsel, Darlene focuses on the client's jobs to be done and whether the terms in a contract and their relationships accomplish those jobs. Darlene looks at the Master Services Agreement as a whole story rather than just a collection of terms. That's a great vision to account for risks in a holistic way and to better advise clients. So, let's tear it down. Hey everybody, welcome back to the Contract Teardown Show. I'm Mike Whalen. The thing with this show is we hang out with super smart people like my friend Darlene, who's this way. Darlene, we talk about contracts, beat 'em up, what we like, what we don't like. Thanks for hanging out. How are you today?
I'm great. I'm excited. This is a rare opportunity for me to talk nerdy contracts.
Lower your expectations, Darlene. Thanks, everybody. What we're doing today is talking about a Master Services Agreement, specifically the Salesforce Master Subscription Agreement. So let me share that with you real quick. If you look at this document, it is about 13 pages long, I think, and covers a lot of ground. There are capital letters. Darlene, real quick, talk to me about what are we seeing in this document? When would a lawyer see this? Why would they care? Why is this thing important?
So many companies will encounter Salesforce. It's a widely used software as a service, or SaaS, as I prefer to call it, and I'm sure so would you. And really, it is a backbone of a lot of companies' infrastructure. And the question we get a lot is this thing negotiable? Is there anything I can do with this one?
Yeah, we talked about that with Martin on the Oracle agreement. Like, Oracle's going to do whatever they want. Salesforce is going to do whatever they want. But we're going to pretend that you have some power against Salesforce and talk through this a little bit. Darlene, before we get into that, tell me about yourself. Are you seeing these a lot in your practice? Tell me about your practice.
Yeah, so I'm the founder of Inter Alia Law, which is an association of lawyers that focus on media, tech, and entertainment. And we all were in-house counsel and practiced in private practice before. So yes, we see these. We act for a lot of vendors of software as a service, as well as acquirers and purchasers.
And you are in the Canada, the great
Toronto,
the
great white north.
Yeah,
yes,
up there.
That's right.
That's right. Awesome. So what we're going to do, guys, is we're going to go through specific sections of this agreement. Darlene's going to talk us through them. And at the end, we'll get to sort of some principles. So let me start here with this. This is fine. We're going to start with the usage restrictions. This is under Darlene under 3.4. It's talking about how customers are using the service. They will not make any service or content available to anyone other than customers or users. They can't sell, resell, license. It's putting a lot of limits on them. What do you think about this section starting in 3.4?
I think the thing that I would say about this is the team often comes to the lawyer and says, we want to use this technology. So do this deal. The person who's selling the technology has their quarter target that ends tomorrow. We get a discount. Can we just get this done? Can you just sign here? Go. And what I always say is, well, what do you want to use it for? Because I can't assess the risk in this contract until you tell me what you want. So the thing that I would draw attention to in this usage restrictions is, the nefarious use that they close off is in the last couple of sentences. It's talking about accessing the service for the purpose of copying it or getting ideas from it or seeing how it works. I've heard that a number of times just to say, well, we just want to see how it works because we have a similar product or on our roadmap, we're going to be getting into this. And I say, just drawing your attention to this clause, you can't do that. You need to have legitimate reasons to use this. Has to solve a business need. And then depending on their answer, how they want to use it, I look first to see that that's possible in this section. And then we look together at what kind of data and different risk profile their usage is going to create for the company.
considering every CRM in the world basically copies Salesforce, I'm sure this one's been violated once or twice. Moving to section 5, wanted to talk about a bit about fees. Under 5.1, it says the customer will pay all fees specified in order forms. This happens a lot where you've got this like sort of master agreement, this large agreement, and then you're getting more specific in order forms. Talk to me about the fees and the relationship with those kinds of documents when you're negotiating contracts.
I really enjoy hearing you talk about order forms and MSAs. This is good.
I'm a
You're
professional.
making it even more fun. You're such a pro. I draw everyone's attention to this clause because, yes, this is a non-negotiable agreement for many purchasers of Salesforce. You're going to find that unless you are a massive enterprise or your organization has some strategic value, negotiating the indemnities, the limitations of liability, that's going to be a challenge. The order form, though, is where the deal terms are. So a lawyer can add real value to their client by helping the business team nail down some of the order form components. So the fees. One thing is often the salesperson on the other side will present your team with a big upfront fee. So as a lawyer, you can do a huge service to the company by just breaking it out into smaller chunks over time. I always recommend that because as a lawyer, you're saying, well, what is the risk of this contract? What if it doesn't do what we think it's going to do? What if we pay all this money and it doesn't work? Your remedies in this contract are pretty limited, so you could at least stagger out the payments and give yourself a little bit of leverage if you go with a concern to your rep on the other side or something like that. So that's step one. And then can I go to disputes, or are you going to...
Yeah, looking at 5.5, I was thinking about the fights. It points out that Salesforce will not exercise its rights under the overdue charges or suspension of service and acceleration section if customer is disputing the charges in good faith and is cooperating diligently to resolve the dispute. Are you feeling confident that Salesforce will keep that bargain?
I always look at so a number of things happen with this disputed clause. Probably you have seen in the contract, all undisputed invoices will be paid. Have you seen that? Mm-hmm. I worry about that as a lawyer reading contracts. So Salesforce has basically come up with a clever way here to say, we won't suspend your access to the product and terminate our relationship with you if you haven't paid, if you're reasonably diligent in disputing the invoice. So acting for software vendors, I always say, make sure that you don't put this thing in your contract that says you have to pay undisputed invoices, customer, because that's a really risky one. What is the dispute? It's, as a lawyer, you do a good service to actually spell out what they have to do if they're disputing an invoice so that it's predictable if you're the vendor. So Salesforce has done that really in a simple way by just saying you're in good faith cooperating to resolve the dispute, but I tend to spell it out a bit more and put obligations on the disputing party. If you're not going to pay, there should be some real reasoning behind, okay, you're not paying, you can't just say I dispute. What does that mean? How long do you have to resolve that dispute? So that's another good, valuable lawyer tip.
Yeah, you don't want the guy who flips the signs outside just saying I dispute as if that's all kosher now. Speaking of sort of consequences, looking at the term, this is under 11.2, talks about the term of the purchase subscription, calls back to the order form as sort of this, document that can break the rules here. But it says, except otherwise specified, subscriptions will automatically renew. And I know you wanted to talk about automatic renewal, so dig into that bit for me there in 11.2.
Again, another spot where we can be valuable as lawyers in helping the sales team structure their order form and the deal terms. So often you'll see that the way that a company like Salesforce gets into an organization is they give a discounted first-year fee. That's very common, and it even references that in this clause, which is way down in the termination section. So it says renewal of promotional or one-time price subscriptions will be at SFDC's applicable list price. That's buried in section 11.2. So being aware that happens in an auto renew, that say you got it discounted 50% on auto renew, which happens automatically, you're going to pay the list price, which is double what you're paying. So you can help minimize the impact of that on your organization by pre-negotiating in the order form some reasonable uplift. So it shouldn't go back to list. You subscribed at 50%, maybe it's indexed to the consumer price index or some pre-negotiated fee.
Hey everybody, I'm Mike Whalen. I hope you're enjoying this episode of the Contract Teardown Show. Real quick, I want to ask you to do me/you really a quick favor. Look down below. You'll see a discount code to join the Law Insider Premium subscription. When you do that, you get access to more content like this. You'll see webinars, daily tips on contract drafting, not to mention access to the world's largest database of sample contracts and clauses. It will help you write better contracts faster. If you want to do it right now, there's a code below, so get there. Also, if you're part of a larger team, if you're in-house or in a law firm, just email us. We're at sales@lawinsider.com. We'll make sure you get a deal as well. Come join us in the community. The code is below. Let's get back to the show. The section that always gets some hot attention is the reps and warranties. I'm looking down at 8.2, and what Salesforce says that they warranty, that the agreement, the order form, the documentation will accurately describe all the administrative steps, and there's a lot of promises in here. This is always hotly contested, like I said. Talk to me about their reps and warranties section. Are you a fan?
Well, I think it's interesting because a lot of lawyers will look at the contract and say, oh, good, there's a rep and warranty. And I don't. I always say, okay, good, there's a rep and warranty. And what's my remedy for the breach of that rep? So in this contract, it's a relief to see that they're warranting that this is going to comply with the documentation. So they're basically saying, we will deliver what we sold to you. Great. So hopefully the lawyer has read the documentation. It's hyperlinked in this document. I find when you're doing SaaS deals with any provider of any size, you must be printing out or reading at least 4 or 5 links to see the whole contract. So if you have reviewed a contract for your company without printing any links, probably a problem in this world. So let's assume we've printed the link to the documentation. We have a sense of what it says. What they are saying, it'll comply. And if you're following the news right now, another major video conferencing calling platform is in the news for having documentation that said they had end-to-end encryption, and it turned out they didn't for all these years. So they're now having regulatory fines and all of that stuff. So I would just say the rep is great, but 2 things. I would get my security team at the client to be confirming that it meets their standards, not just because the contract says it, but because they've done their diligence. And then second, I would say, look at the remedy. And in this case, if you look down at the remedy, it's tied to a it's an exclusive remedy, and it says, if we breach this rep, your remedy is termination. And you get, if you've prepaid the fees because you did an annual upfront payment, you're going to get your portion of pro rata prepaid fees back, and that's it. So don't get too excited. I think some lawyers get excited about the rep because in the old world, you would go to court for a breach of a rep. Right. But you have to watch the limitations on all of those in these agreements. Yeah,
and I was, thinking in terms of principles and bigger picture. I was about to make fun of you for printing things out, but one of the things that I do, as a writer, is I'll print a bunch of things out so I can see the relationship between the chapters. And you had mentioned before we started recording this idea of the contract as a story, as like a bigger picture story.
Yes.
What you seem to be pointing to here is that the relationships between the clauses matter as much as the clauses themselves. So talk me through that. Why do you print everything? Why, Darlene, are you printing everything?
Okay, I have to laugh. I don't print everything. I corrected myself quickly to say, or read it, because I will read it. If it's not fitting together, though, I will print it. And certainly some of these huge documents, you're flipping back and forth between the pages so much. Like we just read, we're talking about fees on page, section 5. You have to go down for the auto renew fee, section 11.2. That I'm not sure you can do as great a job at that if it's not printed. However, I don't print everything. Inter alia law is a virtual law firm.
A likely story, Canada. But talk to me about that. Like, I'm imagining a wall of like Beautiful Mind in Darlene's house where there's just yarns. Yeah, there's just yarns all tying everything together. But what about that? Because again, you mentioned like we tend to focus too much as lawyers on the clause. But, you mentioned with the warranties, if the warranties is not, if those are not tied to a consequence, to some kind of remedy, what really is the point? So talk to me about the relationship between those sections in this document.
I look at contracts as a puzzle so that it all fits together. And I think the first step is you identify the risks with the client. to me, wading into a contract, not understanding what the client is going to use the technology for and what the risks presented to them from this technology means you're not even reviewing it really. So for example, if you're going to put your entire customer list in this contract and the entire intellectual property of your company is based on your customer list, you are using Salesforce in this case to run a substantial piece of your business, so your risk profile is high. So I would be reviewing it and saying to my client, here are the risks in this document. Here's what you get if there's a breach. Here's the gap. So this contract is not giving you the indemnity that you need. They've capped their liability here. Your risk is going to be, say, a data breach or loss of data or, define whatever the issue is, a cybersecurity breach. And then you say, well, do I have a good indemnity for it? Mm-hmm. Is the liability on that indemnity capped in a way that I'm exposed? If it is, then I say to the client two things. Can you get insurance for the thing that isn't covered in the contract? And if you can't, or even if you can, get that as well. And then also use your business team to go through and try to plug the gaps with technology. So for example, if you're really concerned about a leaked customer list, can you use encryption? Can you be doing real-time data backups in case Salesforce for some reason terminates on you with short notice? So I always look at it, the contract is one tool in the overall risk management equation. And done well, you can make strategic changes that even the largest partners would negotiate on. But done poorly, the lawyer's saying, there's risk, you can't do this thing that the business needs to do to be competitive in the world. And I think that's where we get a bit of a bad name, lawyers.
Yeah, I was thinking about, just as a side note, there's a piece on the Law Insider blog that I wrote called The Modern Knowledge Practitioner, which is going to be released as an ebook soon. And one of the things that you hear from a lot of these businesses is that they can't stand the no lawyer, like the one who just says no to everything. And that's the easy thing with these documents is to say, oh, it's so risky, we can't do that. But to be what we call in that document the true counselor, to be able to say, no, here's where your risk profile is, here's how we can address that, like you said, with technologies, with different tools, that's a much better way to address the concern so that everybody doesn't hate you.
Well, and it's a team effort, right? So I've never done a SaaS contract where we're purchasing a service where the entire team isn't involved because they're going to be using it, they're going to be responsible for it. The lawyer basically in many organizations will only interact with it on the contract side. So working on it as a team sport is much better because you assign responsibility. So for example, once you've printed out or read the documentation, you look in there, that's not lawyer speak. That says things like we are PCI compliant and we have an annual audit. There needs to be someone who owns making sure that they have done the diligence on the vendor. That's not the lawyer job. So the lawyer, I don't think it is. And I think that sometimes we lawyers can get in there and almost try to make the business decision for the client, as opposed to pointing out the risks, trying to close them as best we can with an acknowledgement of bargaining power. Bargaining power is real. We can all abstractly issue spot and say, I spotted like in law school, this issue here, that this is a big problem. But if the deal is a must do for your client, then giving good advice is a much bigger picture problem or bigger picture exercise.
Yeah, and that seems to be a theme we're seeing in these videos is that, figuring out what the lawyer job is in the business context is complicated. And I will say for this particular document, we want to root these conversations in these documents. And so the Salesforce agreement will be available at lawinsider.com/resources when we post this. So I hope that you guys will go there and look at the show notes for this episode. Also, Darlene, I want to give people a way to get in touch with you. You've got this innovative law firm that you're building in Canada that's doing really well. What's the best way for people to get in touch with you?
Basically, the website, interalia-law.com. That's the website. I'm on LinkedIn, Twitter.
Yeah, it's not Twitter because I'll DM Darlene on Twitter and she'll just ignore me for 2 months.
You're so right.
Like, why does she hate me? But I'm available on Twitter all the time at Mike Whalen Jr. because I need a therapist and Twitter's cheaper. So reach out to me there. We'll also see you guys next time. Make sure if you want to be a contributor, just email us we're at community@lawinsider.com and you can hang out with me and talk about weirdness. with contracts with people like Darlene. Darlene, thanks for hanging out with us. We'll see you guys
Thanks for
next
having
time.
me.